Good evening, Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Venkatesh Dhon, Vice President, Farhan Dubash, Secretary, other office bearers, senior members of the bar, junior members of the bar, and especially junior members who are here in large numbers, ladies and gentlemen. It's my third felicitation by BBA. First was way back in August 2003 when I was appointed as a judge of the Bombay High Court. Second one was on the last working day before summer vacation of 2019. It was 3rd May 2019 at 10 o'clock. And I was astonished to see similar crowd on that day also. And today is the third one. Now my fairly long journey of 21 years, 8 months and 25 days is over. And therefore now time has come for me to express gratitude to the members of this bar. Mr. Thakkar referred to something which happened in July 2006. 2 years back, there was a regional conference of National Judicial Academy in Chennai, which was attended by several judges of the various high courts and district courts. Eminent member of this bar who now practices in the Supreme Court said publicly that someday I should come very clean about what exactly happened in 2006. Those who heard ceremonial hearing, again, a senior member of the bar who is from Bombay repeated that. And I can say that what Mr. Thakkar said is only 10% of it. But those who have heard me saying in SCBA function that for 3 months, I don't want to give any, at least for 2 months, I don't want to give any interviews. The reason was that I wanted to reflect upon my own career because I believe that even if I had limited the office, I am bound by certain constraints. But this is one thing, what happened in July 2006. I will have to seriously think and someday come very clean about it. I want to say something different. It happened, Mr. Thakkar gave the dates, I think dates were slightly wrong. It happened on Monday and Tuesday, last 2 days of the Chief Justice's tenure. What I want to tell today with great deal of emphasis is, immediately on the next day, eminent members of this bar, led by late Rajni Iyer, they came to my chamber early in the morning and offered compliments. Rajni Iyer was followed by almost 25 to 30 distinguished members of this bar. And it happened immediately on the next day. So today is the time to pay gratitude to them. Then comes 2017, which Mr. Thakkar referred. It was a Thursday on which it happened. Friday, Saturday, Sunday were holidays. And again, that is something about which I will have to speak very openly and right after I reflect upon my career and decide. What is important is, I was told that Bombay Bar drafted the resolution on the same day on which this event happened, where some cases were transferred from my court to another court. And immediately on the next working day, which was Monday, resolution was passed by the Bombay Bar. These are the two things which I must personally thank every member of the Bombay Bar Association. For the benefit of young members of the Bombay Bar, I want to add something to this. I remember 1991, I was a junior lawyer. It is this bar who took initiative and passed a very strongly worded resolution against the 4 sitting judges of the Bombay High Court, expressing that there are doubts about their integrity. Then Appellate Side Bar followed, other associations followed. There was one more resolution a few years thereafter, where something was said about Chief Justice of this court. So therefore, at least from 1985 when I started practicing here, I can say that Bombay Bar Association has taken up these issues which normally no bar association would take up. And I must tell senior members of the bar that junior members of the bar must be informed about all these events because this is the stand which is expected to be taken by the Bombay Bar Association. I have very fond memories of some of the cases which are argued by senior members of the Bombay Bar. One case which I will never forget was where the Maharashtra law enacted in 1995, which was brought into force in 2015, was challenged which prohibited slaughter of cow and its progeny. All distinguished members of the original side bar argued that case, which went on for about 2 months before my bench consisting of my esteemed friend and colleague Justice Suresh Gupte. And what is more important was it was such a sensitive matter. All members of the Bombay Bar who appeared before me showed great deal of constraint. Second case which I remember was challenge to some of the recent amendments of the Bombay Municipal Corporation Act where it provided for charging municipal taxes on capital value. It was phenomenally well argued matter, again went on for days. And third one was, of course, petition filed by Mr. Abdi. And very forceful arguments came from distinguished members of this bar, which led to that judgment. I am going to speak about it. Since I am on that Mr. Abdi's judgment, I want to share my personal thoughts with you. I went to Karnataka. I saw beautiful infrastructure which is provided to the judiciary. As a Supreme Court judge, I had occasion to travel to various high courts. I went to Patna, I went to Ranchi, I went to Allahabad and Lucknow. What kind of infrastructure, fabulous infrastructure has been provided to the high courts in these states. You go and see the old building as well as new building of Patna High Court. Lucknow, of course, is purely luxury. And look at what is happening in Bombay. Of course, it's a heritage building. We all love this building. Where is the place for lawyers to sit? Where is the place for litigants to sit? Litigants squat on the streets. There are no facilities, modern facilities which are available. The judgment of 2018 said that till 30th September 2019, 25 or 30 acres of land, I forgot the details, should be allotted to Bombay High Court, and there is also an order that a separate plot should be assigned for construction of lawyers' chambers. There was injunction order restraining the government of Maharashtra from allotting a very prime plot in Bandra Kurla complex. And 30th September was the date fixed for reporting compliance. Unfortunately, that matter was never taken. And therefore, government parted with that very important piece of land over which there was injunction. And today we are struggling. I am told only 5 or 6 acres of land has been handed over. Now, this is something on which members of the bar will have to stand and say, why litigants and lawyers in Bombay High Court cannot be provided with better facilities. Bombay Bar is such a historic bar today. See, so many members are standing here. There is not even a proper auditorium here for conducting such programs. So this is one area where bar associations will have to take up the issue. I had occasion to read 2017 report of the structural engineer. Structural audit was done of this building. I'll say only shortly that recommendation was there should not be any load on the top floor of this building. Load should be brought down. This is in 2017. Today, half of 2025 is over. So this is a matter of serious concern on which members of the bar will have to really apply their mind and take a stand. Personally, talking about my career, I always believed that judges have to be very strict. I always believed that judges should not permit long arguments unless it is absolutely necessary, considering the facts of the case. And therefore, I always believed that senior members of the bar must be disciplined, and I did that. As I said in the appellate side bar function, I personally believe that if you want to be really successful as a judge, and if you want to really abide by the oath which you have taken under the Constitution, there is no option but to offend people. Without that, you can't perform your duty fearlessly. Because if you have taken the oath, you have to do your job fearlessly. And therefore, Mr. Thakkar talked about third innings. After having worked in 3 constitutional courts for almost 22 years, I have taken a decision not to do anything which will involve adjudication. After occupying the highest office of a judge of the Supreme Court, I felt I should not do any adjudication work hereafter. Advising and consulting, that's a different thing. One more thing which I want to say about bar, especially Bombay bar. In my long tenure of 15 years and 8 months, especially when I was sitting single, my earliest I rose from the court was 6:30. Sometimes it went up to 7, 7:30. And every member of the bar, without exception, cooperated. Even heading a division bench also, I used to extend my court time to 6:30 also sometimes. But every single member of the bar cooperated with me. For all these long years, I never heard any member of the bar telling me that, look, sir, it is already 5 o'clock, so grant me adjournment. No. So this compliment has to be given to both the bars, that are extreme cooperation and patience they showed when they appeared before me. When I stand here today, I have to say something about the present status of justice delivery system. As I said other day that for me the best law school was Bombay High Court. As a lawyer, as a judge. Why I say as a judge? I was purely a civil practitioner. Thanks to Chief Justice Bhandari, in 2005, before summer vacation, he called me and told me, he said that, Brother Oak, you have long tenure. So now from June, you have to do bail work. And that bail work will continue for 2 sessions. I was really taken aback. My mentor, Justice Ajit Shah, was also in the chamber. He was the senior most judge. He said, for you, there won't be any difficulty. Vacation of 4 weeks is intervening. So devote the entire vacation for reading the criminal law, which I did. And I must admire the foresight of Justice Bhandari. And thereafter, successive Chief Justices gave me criminal roster, quashing, then division bench, dealing with the appeals. And it was a great learning experience. I remember my second last sitting in Bombay High Court, I believe with Justice Gadkari, heading a criminal division bench. I remember distinctly that at least in 10 cases where accused had undergone more than 12 years of sentence, we granted clean acquittal, not benefit of doubt. So my journey in Bombay High Court was a great education. The best education I had was as chairperson of the Maharashtra Legal Services Authority, when I made it a point to visit all central jails except Ortho Road Jail in Mumbai. And that was a great learning experience. Interacting with the prisoners was a great learning experience. And as luck would have it, I landed in Bangalore. I wanted to do criminal work, especially criminal appeals. I decided not to do it because it's not like Maharashtra where session judge also records evidence in English. It was only in Kannada. And I thought that sitting in first appellate court, I should not decide and appreciate evidence on the basis of translated version. And Supreme Court, I thought that I'll get opportunity to decide very important issues concerning civil law. But when I started presiding over the bench, it was PMLA, UAPA, and all bail applications, plus IB code matters and tax matters. That was the assignment given to me. And I must thank my Chief Justice here, who made me work on the criminal side against my wishes. And therefore, I could do some work on the criminal side in the Supreme Court. Talking about the justice delivery system, I am not going to quote those figures of pendency in Bombay High Court, or for that matter, all courts in Maharashtra, which are available on public domain on the National Judicial Data Grid. I must say that situation is alarming for 2 reasons. One is sheer numbers. And second is, now today we have a scenario where in magistrate tribal cases, where 20 years back or 30 years back, bail was granted for asking, people had to knock the doors of the Supreme Court. Only one example I am giving you. The other issue, talking about Bombay High Court, we have sanction strength of 92. I believe when Mohit Shah was the Chief Justice, only once we reached 74. And I don't think we have crossed that figure. I may be wrong, but I don't think we crossed 80. And look at the filing which is happening in Bombay High Court. Not only here in Mumbai, are you aware that filing in Aurangabad bench is more than filing on the appellate side of the Bombay High Court principal seat? And with this kind of filing, we are struggling with the just strength of less than 70. How we are going to deal with this situation? Look at so many arbitration matters which are filed. There are 30 petitions under section 34, 37 appeals. So many appeals are pending. People are languishing in jail. Bail petitions are not reaching. Now we have to find out some solution to this. And I want to say something about the solution also. One reason why we are not able to fill in vacancies is about the uncertainty in the process of appointment of the judges. I am the one who always batted for transparency. Today we have practice of publishing Supreme Court collegium resolutions on the website, on the public domain. Today, the fact of the matter is that once that resolution is published, professional life of those whose names are mentioned in the resolution, those whose names are recommended, professional life gets affected. I have seen worse things happening in Karnataka where some of the recommendations of 2018 were not cleared for 1 year. And that is the uncertainty. Because of this uncertainty that the lawyers are not willing to accept judgeship. Fortunately, during the tenure of Chief Justice Khanna, now entire collegium documents are on public domain. And I'm surprised to note that those who are criticizing collegium system, I'm not saying that it is the best, but those who are criticizing collegium system, they have not commented upon what is put on the website. If you have not read it, please read it. At every possible stage, the government has say. When the names are sent by the Chief Justice of Bombay High Court, Collegium of Bombay High Court or any High Court, the Governor and the Chief Minister can offer their comments on the candidates. Then there is full-fledged IB inquiry. What kind of IB inquiry is held? That is also on the domain, public domain. We have put those forms on the public domain. Very thorough IB inquiry. And with report of the IB inquiry and the comments of the Law Ministry and comments of central government, that the matter comes up before the Supreme Court Collegium. So there are filters. And please look at those formats which are there on the website. What kind of process takes place? What kind of thorough inquiry is made by IB? And then after collegium clears it, if you are going to take 9 months or 10 months, who will accept, who will say yes to the call given by the Chief Justice to accept judgeship? I always said that on public platforms. I had recommended one young and bright candidate at the age of 45 from Karnataka. And after 1 year, he withdrew his consent because he found that appointment may not be cleared. And of course, the loss to the judiciary is now gained to the Supreme Court because he shifted his practice to the Supreme Court and is extremely successful. So this is one area on which associations like Bombay Bar Associations will have to take a stand. Because unless we take a stand and ensure that after the collegium recommendations are made, the names are cleared within a short time, the Chief Justice of the Bombay High Court and the collegium members will find it difficult to convince the members of the bar. This is not true only about Bombay High Court. I am talking about all high courts. Of course, the grassroots level situation in many high courts, smaller high courts, is different. There, perhaps still Chief Justices are able to persuade people to accept judgeship. But this is one area of concern about delay in judicial appointments. And therefore, now see the scenario. I believe if I had done some work about what should be the possible just end, because you know there was a judgment of the Supreme Court of Justice Chandrachud in 2016 or 17, where a formula was laid down how to calculate the just strength that was applicable to our district and trial judiciary. Now, even 92 judges are not good enough for Bombay High Court. Look into the kind of filing which takes place in Bombay High Court. And other issue which bar will have to address again, are we going to get rid of arrears only by creating one more bench? Perhaps Bombay High Court is the only High Court which has 3 benches. So even whether that is the solution to create one more bench, even that issue will have to be addressed by members of the Bombay Bar and all members of the bar. And ultimately, it so happens that it is not only judges, but even lawyers get blamed for delay. Litigants go to the lawyers and complain about matters not reaching. So lawyers have to also face the brunt. So these are some of the institutional issues, namely having proper infrastructure for this historic High Court. Secondly, to have proper just strength in this court. And thirdly, we must ensure that those who give consent, their appointments are cleared within reasonable time. These are the few institutional issues which I think members of the bar must apply their mind and take some action. It is already 6 o'clock. I don't want to consume more time. But I will close by saying that after I demitted office, I realized that how important is the office of post of a judge. In fact, in Scora function, advocates on record function, I said that somebody said in the function, I think secretary or treasurer said that now Justice Oka must be looking for freedom. I said no. The best freedom I had was as judge of the 3 constitutional courts. And therefore I said when I demitted office that I had tinge of sadness in my mind that I won't be able to do the judicial work. I thank Bombay Bar Association for felicitating me, and I thank all the members of the bar who are here in large numbers, and I'm sure that younger members of the bar will continue glorious traditions of Bombay Bar of taking stand on all institutional issues. And that's the, not message I will say, that's the request which I want to convey to the younger members of the bar. I again thank everybody from my bottom of my heart. Thank you.